Hello friends, in the series on the income tax cases, today we will discuss the case of BAE Systems Information and Electronic System Integration Inc. versus Additional Commissioner of Income Tax. This case has been reported in 105 ITR Tribunal Short Notes 18 and the matter has been decided by D Bench of ITAT and the date of the judgment is 23rd June 2023. In this case, the Assessee was a company which was incorporated in USA and the company was selling its software in India. The Assessee during the financial year ending 31st March 2019 has made sale of the software and has included this sale into its income. But the purchaser of the software deducted T.D.S. in the next financial year, that is financial year ending 31st March 2020. When the Assessee filed the return for the financial year 31st March 2019, Assessee claimed that T.D.S. which was deducted by the purchaser in the financial year 31st March 2020, meaning thereby that there was mismatch in 26 AS of the financial year 2019 and 2020. So the CPC did not allow the credit of the TDS which was deducted in the financial year 2020 in the financial year 2019. The Assessee was claiming the TDS in 2019 which TDS was reflecting in the 26 AS of Assessee in 2020 because the purchaser of the software has not deposited the TDS in 2019 but the Assessee has shown the income in 2019. CPC disallowed the credit and accordingly the CIT appeal also disallowed the credit. When the matter came to the ITAT directed the assessing officer that to verify the facts that the Assessee has shown the sale of software into the income and allow the credit of the TDS which has been reflecting in the 26 AS of 2020 and which was in correspondence to the sale of the software which was incorporated by the Assessee into its return of income in 2019. The second issue was that the Assessee raised an additional plea before the ITAT on the decision of the Supreme Court in the case of Engineering Analysis Center of Excellence Private Limited versus CIT which was reported in 432 ITR at page number 471. In that Supreme Court judgment, it was held by the Honorable Supreme Court that the sale of software is not taxable. So, on the basis of this judgment, the Assessee raised an additional ground. But the department was saying that this additional ground should not be allowed. For this, the ITAT said that if the Supreme Court judgment was not available at the time of the assessment or at the time of the first appellate authority, that is the CIT appeal, and the judgment has came later on, and if the judgment is in favor of the Assessee and the Assessee wants to raise the additional ground on that behalf, then it should be allowed to the Assessee. Meaning thereby that if the additional ground is on the basis of some judgment of higher forum which has came later on and which was not available at the time of the earlier appellate authorities or the assessment authorities, then on that basis the Assessee can raise additional ground. So the ITAT allowed the additional ground and directed the assessing officer on this point also that in light of the facts and circumstances of the Assessee and in light of the Supreme Court judgment in the case of Engineering Analysis Center of Excellence Private Limited versus CIT to allow the ground if the assessing officer feels that according to the facts of the case the benefit should be given to the Assessee. Friends, this case is very important because this is a normal practice that sometimes when some favorable judgment comes and the assessee wants to take some additional ground on the basis of some judgment, then the assessee can do so according to this judgment. At the end of this video, once again I am repeating the name of the case. The name of the case is BAE Systems Information and Electronic Systems Integration Inc. versus Additional Director of Income Tax, and this case has been reported in 105 ITAT Tribunal, short notes 18, and the matter has been decided by Delhi ITAT D bench, and the date of the judgment is 23rd June 2023. Thank you, friends.